Please be seated. Mr. Reichler, may I suggest that you begin at paragraph 34 of your remarks?
Yes, of course, Madam President. Thank you very much. And this is where I begin my discussion of the fourth preliminary objection, and I will begin anew at that paragraph. Turning to Myanmar's fourth preliminary objection, we heard absolutely nothing new on Friday, and there is thus very little else to say today. Can it seriously be doubted that a dispute existed between the applicant state and the respondent state at the time the application was filed? Plainly, it cannot. On the facts, the Gambia directly accused Myanmar of acts of genocide against the Rohingya during the clearance operations of 2016 to 2018, relying explicitly on the two voluminous reports of the UN fact-finding mission, as well as other compelling evidence. As well as on other occasions, these accusations were made at the UN General Assembly and in a note verbal addressed directly to Myanmar. Myanmar rejected these applications publicly, and it denounced the two fact-finding reports and their contents as false. It is simply unarguable that there was no dispute between the Gambia and Myanmar over the facts. On the law, the Gambia expressly accused Myanmar of violating its obligations under the Genocide Convention in carrying out genocidal acts prohibited by the Convention against the Rohingya. Myanmar publicly denied its responsibility for genocide. What else is required to show a dispute on the law? On Friday, counsel for Myanmar again argued that 30 days was insufficient time for Myanmar to respond to the Gambia's note verbal, accusing it of violating the convention. This is another untenable argument, especially in the context of a treaty that seeks to prevent the gravest of harms to human persons. Myanmar had previously, at the UN, rejected these same legal arguments in the face of accusations by the Gambia and others. The existence of a bilateral dispute over whether Myanmar was in violation of the convention was already clear even before the Gambia sent its note. Mr. Staker chose to ignore a very significant point that my colleague, Mr. Suleiman, made last Wednesday, that Myanmar has admitted that it knew at least a month in advance of the Gambia's application that it was coming. This means that Myanmar was well aware that a legal dispute existed at the time it received the note, if not even earlier, and it chose not to respond to it. Mr. Staker's refusal to engage with this fact is especially glaring because the same point was made by the Gambia at the hearing on provisional measures, in its memorial, and in its observations on preliminary objections. Again, Myanmar goes absolutely silent when the evidence goes in a direction that undermines its arguments. Madam President, there is no legal or factual basis for any of these preliminary objections. Every one of them is a sham. Professor Sands said on Wednesday that they were concocted, and at the risk of being called his proxy, he was absolutely right. Myanmar is not the first respondent state and will inevitably not be the last to put forward groundless objections, not in the expectation that the court will sustain any of them, but to extend the proceedings and delay the final judgment for as long as possible. This might not be calamitous in a territorial or maritime boundary dispute where there is no threat of armed conflict between the two neighboring states. But that is not what this case is about. As we pointed out on Wednesday, the UN Special Rapporteur has recently warned that the 600,000 Rohingya who remain in Myanmar, quote, face an existential threat and, quote, remain at grave risk of mass atrocity crimes. The longer this case takes, the more extended and the graver the risks to their existence as a group will be. The Gambia therefore urges the court, after due deliberation, to issue its judgment on jurisdiction and admissibility as expeditiously.
I thank Mr. Reichler, and I shall now give the floor to the agent of the Gambia, His Excellency Mr. Dauda Jallow. You have the floor, Your Excellency.
Madam President, honorable judges, it is an honor to address you again as the agent of the Republic of the Gambia. As a state party to the Genocide Convention, the Gambia came to this court to protect its rights under the convention, to ensure that the erga omnes partes obligations undertaken by Myanmar under the convention are fulfilled. Those obligations, not to commit genocide, to prevent genocide, and to punish genocide, are owed to the Gambia and all other state parties to the Genocide Convention. It was the Gambia alone that filed the application before this court. The Gambia has been open about its dispute with Myanmar. We openly raised this dispute at the UN General Assembly. We sent a note verbal to the Myanmar to clearly confirm the nature of this dispute and put Myanmar on notice. Myanmar officials publicly confirmed that they were indeed on notice and expected the case a month before it was filed. We have openly welcomed support for this effort from other states and international organizations. Madam President, honorable judges, Myanmar has no reservation to Article 9 of the Convention, which governs your seizing and jurisdiction. Having consented to that provision of the Convention upon ratification, Myanmar cannot escape it now. The Gambia urges this court, as the guardian of our moral and legal compass under the Genocide Convention, to reject all of Myanmar's preliminary objections and to advance this case to the merits phase. Madam President, I shall now read out the Gambia's final submissions. In accordance with Article 60 of the Rules of Court, for the reasons explained in our written observations of 20th April 2021, and during these hearings, the Republic of the Gambia respectfully asks the Court to A. Reject the preliminary objections presented by the Republic of the Union of Myanmar. B. Hold that it has jurisdiction to hear the claims presented by the Gambia as set out in its application and memorial, and that those claims are admissible. And C. Proceed to hear those claims on the merits. Madam President, honorable judges, I thank you for your kind attention. I would like also to take this opportunity to thank all members of the registry, court staff and security, and the interpreters for their dedicated work throughout the hearings. Thank you.
I thank the agent of the Gambia. The court takes note of your final submissions that you've just read on behalf of the Gambia. This brings to an end the hearings on preliminary objections raised by the respondent in the case concerning application of the Convention on the Prevention and Punishment of the Crime of Genocide, the Gambia versus Myanmar. I thank the representatives of the parties for their assistance that they have given to the court by their presentations in the course of this hearing. In accordance with practice, I shall request the agents of the parties to remain at the court's disposal to provide any additional information the court may require. The court will now retire for deliberation. The agents of the parties will be notified in due course as to the date on which the court will deliver its judgment. Since the court has no other business before it today, the sitting is now closed.